Well, ladies and gentlemen, it's a very great pleasure for me to be back here in UNIDROIT, an institution with which I've been involved for some 45 years and for which I have a very deep affection. The pleasure, of course, is very much tainted by the sad untimely death of our president, Professor Alberto Mazzoni, who I remember well as a leading practitioner, as a scholar, and as a great president of this institute. I have had many discussions with him over the years, particularly when we developed the Queen Mary UNIDROIT Institute of Transnational Commercial Law, in which he played a very important role and indeed delivered the inaugural lecture of the Institute in London some 18 months ago. I didn't really know Alberto well enough to claim the privilege of friendship, but he had the great gift of making everybody he spoke to feel a friend. So I suppose in that sense I was a friend. Indeed, I think we all, in some sense, felt ourselves as friends, and he will be a great loss. Well, that now brings me to this would take more than a couple of hours, par for the course for UNIDROIT Governing Council meeting. Actually, let me just reassure you, I am going to speak for no more than 10 minutes. My colleague Geoffrey Wool is going to speak for no more than 10 minutes. We thought there might be then a short period for questions and comments before we move on. I know there's a meeting of the Permanent Bureau, of the Permanent Committee sometime. I'm not sure whether that's taking place this evening, but at any rate, we will be brief, and then we're very happy to take questions, comments, and so on. Just to remind you, this is the launch of the 4th edition of the official commentary on the Cape Town Convention on International Interests in Mobile Equipment and the Aircraft Protocol. I'd like to start by expressing my thanks to a few people. First of all, my friend and colleague Geoffrey Wool, who is the President of the Uniform Law Foundation and Secretary General of the Aviation Working Group, who has played an enormous part in bringing about the Convention and Protocol. Also, two colleagues of his, William Peels and John Pritchard of Holland and Knight, respectively Chairman and Member of the Executive Committee of the AWG's Legal Advisory Panel, with whom I've had various vigorous exchanges, Rob Cowan, the Chief Executive of Aviator, which runs the registry, Marla Weinstein of ICAO, many helpful comments, Professor Jonathan Harris in England for help on the conflict of laws, and then a special thanks to the UNIDROIT Secretariat, Marina Schneider, the Senior Legal Officer and Treaty Depository for updating the appendices, Isabel Dubois for formatting the text, tables and index. It was a very formidable task. Bettina Maxion, the librarian, for literature searches. And finally, Isabel Dubois, not finally, penultimately, Isabel Dubois for a very difficult task of formatting the text, the tables and so on. And then the wonderful Lena Peters, whose meticulous reading of the drafts, picking up errors, organising everything, was, I don't know what I would have done without that. And of course the printers did a pretty good job too. And then finally on the thanks, a word of appreciation to the government of South Africa, who hosted the diplomatic conference in Cape Town, which some of you may have been at, November 2001, and generously agreed to host the diplomatic conference in Pretoria to adopt the protocol on mining, agricultural and construction equipment. Now, within these four walls, I should tell you there was some anxiety way back about the organisation of the 2001 diplomatic conference. And the reason for that was that never before had any diplomatic conference been held anywhere in the continent of Africa. Well, we needn't have worried, actually. The organisation was superb. Also, wonderful hospitality, including an open-air evening dance in which some of the more elderly delegates were seen cavorting merrily with the youthful ladies of the UNIDROIT Secretariat. It broke the ice. It was a wonderful evening, and the conference just moved forward with great enthusiasm. Now, I ought to say a few words about the official commentary. As I came to realise, actually, it takes many years of deep reading before issues underlying the text come to the surface. Actually, one never quite gets to the end. And then, of course, when you get the practitioners who are having to wrestle with real live problems, popping up and saying, well, what is the answer to this question? You know, one realises actually what is the answer to this question. So we've had vigorous exchanges, great debates. We've generally reached agreement, but if not, we've reached agreement to disagree. But these two instruments run to 99 articles, and they stand up marvellously well to rigorous examination, because, of course, in the context of a 3-week diplomatic conference, it's very difficult to get everything right. You're always trying to catch up time. The last meeting, two of us had, Martin Stanford, former Deputy Secretary, and I think we both got up at 6 o'clock one morning, went to bed at 1 o'clock the following morning. This is not guaranteed to enhance intellectual ability in the middle of the night. But still, we sort of got by. What these two instruments have done is to introduce an amazing number of innovations into cross-border commercial lawmaking. First of all, the creation of the international interest, which is an interest not derived from national law, but created entirely by the Convention. Secondly, the establishment of an international registry to record international interests and other interests for priority purposes. Thirdly, the breaking of previous taboos against rulemaking in the field of property law, priorities and insolvency, all of which were considered to be too dependent on local conditions to envisage an international instrument, at least at the private law level. Fourthly, the elaborate declaration system, which on matters of national legal sensitivity enables states to opt out of, or indeed not to be bound unless they opt into certain provisions. And then finally, a provision in the final acts and testimonium allowing states a 90-day period to make provisions for linguistic alignment of the texts in order to bring them into line, because it's very difficult for any translation service wrestling the 6 languages to make sure they are in alignment. So that was very good. Actually, there's one more point, actually. Amazingly, how to make, because this was planned to come after the UN Convention on the Assignment of Receivables and International Trade, how to make, but it wasn't, because the Cape Town Convention came first. But we wanted to be sure that the Cape Town Convention would have priority. How to make an earlier convention trump a later convention? It was actually the American delegation that came up with the answer. It's quite easy. We pass a resolution saying that on the deposit of the UN Convention with the Secretary General of the United Nations, a new clause will be inserted into the Cape Town Convention saying, in case of inconsistency, Cape Town Convention will prevail. Brilliant thing. I've not met an international lawyer who's ever come across this expedient, but I recommend it for future use. Now, the new... there are a sprinkling of errors, omissions, and ambiguities, which I came across. There's actually even a provision in the Convention on how to construe references to administrative authorities in territorial units when no such references are anywhere to be found. So we have an utterly useless provision, but that's only put in to make sure that the reader is following carefully. So these matters have necessitated what is sometimes a creative approach to interpretation, albeit founded firmly on the Vienna Convention on War Treaties. But the constructive involvement of the aviation industry has been a great help. Now, the primary motive for a new edition is the advent of a new protocol. Because when a new protocol comes in, of course, one has to do a commentary on the convention as well as the protocol, and it has to be up to date. And if it's made up to date, then, of course, we have to ensure we amend the previous commentaries so that they all say the same thing. This is a nightmare for me, because every new protocol got to go back to the others. So now with the MAC protocols, no doubt an official commentary will be required. That hasn't been decided yet. And then, of course, all three previous commentaries will have to be updated, except the aircraft property, this one, which I'm certainly not going to update anymore. Also, there have been a number of new developments, experiences with practitioners, developments with the industry, and so on. So the main new features are first of all, the 8th edition of the regulations for the international registry made by ICAO, which have been approved subject to minor editorial adjustments, so they're all fully analysed in the new edition. An examination of the important question as to which states are to be regarded as relevant contracting states to make declarations. That hadn't been previously dealt with, but there were so many questions raised, I thought I'd better deal with it. Complicated, actually. An expansion of the treatment of registration and other acts by trustees or other representatives, bearing in mind the concept of the trust is not really fully known. It's sort of partially replicated, not fully known in civil law jurisdictions. I thought, well, I'd better say something about that. A more detailed treatment of accessions and other attachments. Actually, the MAC protocol has got some interesting thoughts on that. The examination of procedure to obtain discharge of improperly registered non-consensual rights or interests. People are popping things on the register, claiming to have a non-consensual right or interest, but they do not have. Then the problem is how to deal with it, because this casts a shadow on the title of the holder of the registered international interests. Luckily, the Irish courts, who have jurisdiction, have been wonderfully receptive to the problems of fast decisions to clear the registry of improper registration. So that's, on the whole, worked out quite well. Then there's an expanded treatment of deregistration and re-registration of aircraft. A further examination of Articles 42 and 43 on jurisdiction and consideration of the 2015 Hague Convention on Choice of Court Agreements. An enhancement of the many conflict of laws issues, where I had the advantage of talking to a conflict of law specialist, and overall a substantial revision and expansion of the text by some 100 pages. Now, different readers may use the official commentary for different purposes. Most use it to obtain a clearer understanding of the convention and protocol. Some, on the other hand, appear to regard it as an infallible cure for insomnia. One page, and you're out. I can recommend it. It actually does work for those that don't have the same interest as others. Either way, I would say please spread the word about the new edition, as all receipts go to the Uniform Law Foundation to support the invaluable work of UNIDROIT. So my thanks once again to UNIDROIT, to the Secretary General for authorising this session, to all those who helped bring the new edition about, to my long-suffering wife, Catherine, who has in many respects shared the pains of authorship, and to all of you for coming here tonight. There are, for all members of the governing council who are interested, there are complimentary copies, well, no more than one each, of the official commentary at the back of the hall if you want to pick up one on the way out. Jeffrey.
It is an infinite honor and privilege to be sitting next to Roy on this occasion, as it has been virtually every moment I've worked with him, including the first teaching of transnational commercial law at Oxford. Roy, of course, is too humble to say just how important this work has been, and I'd like to say a few things about it and give some details. First and foremost, as you know, the international law community has moved towards substantive, complex instruments rather than generalized standards and choice of law approaches and political agreements to solve problems. And it follows from that the risk of misunderstanding and not applying the instrument the way it was intended to be applied to produce the benefits that were intended to be produced is substantial. And I'm understating here. Countries do not follow or do not comply with the treaty. Perhaps some do for political risk, rule of law reasons, but that's unusual. It's really the complexity of the instruments and the need to understand that. And it was against that backdrop that the AWG with the US government proposed the resolution that gave rise to the official commentary. The co-sponsor with UNIDROIT, ICAO's first view was there's no need for an official commentary for any instruments. One can study these words closely enough and everything will be clear. Well, 831 pages later, maybe ICAO has reconsidered the importance of the official commentary. I would like to give a little bit of life to this by explaining by way of example some things that this document has done to further the utility of the instrument. First and foremost, a number of countries have put in their legislation that the treaty is to be interpreted in accordance with the official commentary. This is, of course, a great credit to Professor Good, and we can all agree he is the we need no artificial intelligence if we could clone Professor Good, but separate from his pure intelligence, he has been constantly studying these topics, going to these 10-hour meetings with the Aviation Working Group and others on a, for the last 15 or 20 years to perfect that knowledge. And that is important because it is the authority and the credibility of the text and the author that gives rise to its influence in most of the cases. And as this volume has moved from 150 pages in the first volume to 831 pages in the fourth volume, it has become more and more important. And I'll now say why, to be more specific. The official commentary has really done 5 different types of things functionally. Number one, it has corrected errors, fundamental errors. So Article 14 of the Aircraft Protocol has a priority rule, which is incorrect. It was a mistake, and the commentary says, paragraph 2 cannot therefore be given its literal meaning, which is against the intent and is wholly inconsistent with paragraph 1. Therefore, it should be read as follows, and he restates the rule. Completely corrects a fundamental mistake on the priority of a buyer of equipment. What could be more fundamental than that? Number one. Number two, and many people's favorite now with some sentiment, the official commentary makes the instruments work and deals with practical issues. So the most famous one is the power to dispose. The background, without going into any detail, is if I have a superior right, I'm a leasing company, and that is the analysis. No one can have a greater right than I have. There pretty much is no reason to register anything with the International Registry. And this is fundamental to providing certainty. So Professor Good said concisely that the power to dispose is wider than the right, and the convention gives rise, first, and sometimes he says it is implied, but basically says the convention itself implies a priority rule that if you don't register, you lose. regardless of what the law was. That single sentence has forced the entire world to register every interest. That one sentence, because no one could give a clean legal opinion because of what Professor Good said in the commentary. That's number, and I'm not exaggerating at all here. Number two. Number three, the official commentary deals with some of the most complex legal points that were either not thought of very carefully or were glazed over. Without going into detail, one of the first issues faced by the aviation industry and all the industries is the difference between an assignment and an innovation, which is a classic difference in approach. Hans-Georg and many colleagues around this table, we spent so much time discussing these different concepts. But the problem was that if you don't have a single rule, then there's great uncertainty in the transactional context. So Professor Good in the commentary in the first paragraph explains how complex and how due attention should be given to different national laws. And then flat out says that with certain characteristics, such a transaction is an assignment regardless of whether it's an innovation under national law, which, by the way, went against his own system of national law, so that there was clarity in the context of this very, very complex situation. And the commentary did more than just correct problems and make the system work and solve ambiguities. And now I'm getting myself in a bit of danger, especially as I think this is recorded. But the commentary helped create concepts. For example, the role of fractional interests. There is not a single word in the convention about a fractional interest, a sub-property interest, which is fundamental in the aviation industry. And Professor Good created a framework through the words in the official commentary that struck precisely the right balance between the needs of the community to make sense and what the text said and a reasonable implication of that. And if anyone thinks that Professor Good is not forward-looking, in other aspects that needed to address the relationship between technology and the international registry and the text, he found a way to put systems around concepts like the right to discharge and non-consensual interest that made sense. I could go on. I'm at 10 minutes, although I will note you took almost 12 minutes. But I could go on and discuss the enormous value of this and how much the official commentary has contributed to the Cape Town system, how it has made possible future protocols by encapsulating all the knowledge developed over years and years to be deployed for the benefit of, in this case, the MAC system. And in closing, as this document was at the printer, many of you are aware there was a large bankruptcy in Brazil, which took place, and 7 or 8 issues came up already. And the first instinct was send them over to Professor Good. Please address these to save time and effort and money, and unfortunately was at the printer. And because of that, it's going to cost the community several $1 million in transaction costs simply because it didn't get there fast enough to be dealt with in the community. And I'm not exaggerating at all. Luckily, we will have the Cape Town Convention academic project to annotate. We already have 10 annotations until the next official protocol, official commentary in connection with the shipping protocol or the like. So I just want to say in closing, and I say this with the backing of the world's aviation community and certainly my view as well, that we owe Professor Good a debt that cannot be quantified in his work on the official commentary to make the instruments the success that they are. Thank you very much.
Well, thank you very much, Jeffrey. much appreciate that. Now, we have an opportunity for questions, for comments. Some of you, at least, I'm sure, will have read previous editions of the official commentary. But those who haven't are very welcome to ask any questions or indeed make any comments. Preferably, if there are to be comments on the commentary, then complimentary ones would always be appreciated. I'd like to Anna.
Thank you very much. Just a piece of information which might be interesting for all those who are present here. We have already sold 160 copies, hard copies of the official commentary before it even was printed, because this really underlines the importance for those who really are in this particular business of having the guidance of the official commentary. So it is in itself a great acknowledgement of the importance of this instrument.
Thank you, Anna. I'm told actually that there are also 30 orders not yet processed, which will bring it up to nearly 200, which is actually very gratifying. Now, thank you, Anna. Yes. Hans-Georg, yeah.
Thank you very much, Roy, for giving me the floor. I think this is a very good opportunity to congratulate you for everything you have done for this project, to express our deep gratitude, and I think I can speak on behalf of the whole Governing Council to express our deep gratitude to you, being a rapporteur from the very beginning, from more than 20 years of the project, and not only drafting all these difficult texts in the Cape Town Convention and its protocols, but also writing these impressing commentaries on all the base convention and these protocols. So, Roy, thank you very much for all you have done for this project, for all you have done for UNIDROIT, and thank you very much for all these new ideas I just got. I remember I wrote a commentary on the third edition of this commentary in a German law review on aviation law. Now I have some more ideas for my commentary on the fourth edition. Thank you.
Thank you very much. That's very kind.
Yes, thank you. Just as Hans-Georg took the floor before me, I have the same reason to do just that, because I've also been involved with the project from rather early on. And just this, I've said this before to you, of course, to Jeffrey also in a different capacity, say thanks and just to express the deep gratitude that I personally have, and I certainly can assure you that it is not because of the commentary or your work that you have carried out that Finland has still not yet ratified the convention and the protocol. So sorry for that. So that's a problem we have to solve, but really, I mean, it's been wonderful to follow it, certainly from the outside sidelines over the years now since the early 2000s, and thank you so much.
Thank you very much. Antti Leonen chaired the sessions in Cape Town, and with great, wonderful combination of diplomacy, firm control, and a unique technique for speeding things up. So we approached the lunch hour. All the lights were flashing on his screen, indicating people wanting to speak. He said, well, you know, we are getting near lunch. It would be nice to conclude before lunch. So may I invite those who had planned to speak to decide that perhaps they don't need to speak, whereupon all the lights went out. Jorge.
Thank you, Sir Roy, for giving me the floor. I think that we have to acknowledge several things. First of all, you masterminded this convention of international interest in mobile equipment, and it's one of the highlights of our institute. We are really very proud about them, and I think that all my distinguished colleagues, I'm positive they agree with me that we should express our gratitude to you for this very important international convention for the international community. But I don't want to miss also Jeffrey Wool. Jeffrey Wool was one of the main operators of this convention, and to both of you, to arrive to a 4th edition in official commentary is really an achievement. So thank you so very much, and you should be very proud about it.
Thank you. I would say Jeffrey is indeed a great operator. I remember in the drafts of these things, I said, Jeffrey, you will never ever get away with that. But he did, generally speaking. I used to joke with him, I said, the thing is, I know your technique, Jeffrey, he's a hustler. You asked for he asked for the moon in the hope of getting the Earth, and he did pretty well.
I am very curious to learn about this official commentary. And I wanted to ask you, Roy, why did you call it official? Because apparently what you've been doing, you were spotting out mistakes, you were creating new concepts. Is this very official? And I'm now waiting for the 1st edition of the non-official commentary. No, but so why official?
Not my label. The resolution passed at the diplomatic conference, as a matter of fact, when I wasn't even concentrating at the time, said that from the United States actually proposed that the chairman of the drafting committee, me, should prepare an official commentary, that's what he called it, on the convention. Well, I wasn't going to disagree with him, of course. And then later on he said, of course, it's got to be done within 3 months. I hadn't looked over the page of this resolution. I said, there's no way it's going to be done in 3 months. But so the answer to your question is, that was what was mandated by the diplomatic conference. The label had nothing to do with me. Everybody's looking forward to a drink somewhere or other, I expect. I think I detect we've come to a natural end to the proceedings. May I thank you all very much. I'd like to thank Jeffrey, but everybody here, and including in particular the Secretariat. I should also like to thank the previous Secretary General, Angelo Estrella Ferrer, who's with us today. Always had a lot of help and support from him, as indeed I have from the present, the new Secretary General. So it's been a great occasion. This wonderful institution, which is very old. The building is exceedingly old. Sort of looks old. Maybe some of the residents are sort of gently aging, but still there's a great vitality about this institution, which I think is really wonderful, actually. The staff are so dedicated. There's a real sense. I'm very much in favour of small organisations, actually. They really work, I think. They're very efficient, dedicated, lively. We have a lot of fun. Anyway, this, I think, brings us to a close. Thank you all very much.